Take a look at this racist caricature of Chinese laundrymen that appeared in Frank Leslie's illustrated newspaper in the 1870s. In this video, we're going to talk about selective prosecution, and we're going to come back to this caricature to talk about an 1886 Supreme Court case. Prosecutors enjoy an immense amount of discretion in deciding if to charge someone with a crime, and then if they do, what specific charges to file. In fact, we describe the prosecutor as the most influential member of the courtroom work group because of this decision-making power. However, there are limits to that discretion. One of those limits is the grand jury system, allowing a group of citizens to enter into the process, and that limits the prosecutor's decision-making power. They need to go through a group of citizens before they can file charges. And another one of those areas is a procedural defense known as selective prosecution. This is based on the 14th Amendment's Equal Protection Clause, which reads, "Nor deny to any person within its jurisdiction the equal protection of the laws." The selective prosecution defense is based on the idea that the defendant was selected for prosecution for reasons forbidden by the Constitution, such as race, religion, or sex. This defense does not proclaim innocence or deny committing the crime. The main argument in using this defense is that the defendant is not the only person committing the crime, but other people are not being tried and convicted, and the only reason the defendant was selected for prosecution is because of a bias against the defendant. Selective prosecution defenses are very hard to win because it is difficult for the defendant, who has the burden of proving that discrimination on the part of the prosecution exists. They must prove that he or she was selected for prosecution because of the biased reason, and that people outside of that class were eligible for prosecution but were not prosecuted. That's just hard to do. However, in this Supreme Court case, we have an example of selective prosecution. So as this illustration depicts, Chinese immigrants were treated poorly in this time period and victims of racial discrimination. You can see how they were viewed simply by looking at how they were depicted. So okay, let's talk about Yik Wo versus Hopkins, 1886. First though, I want to mention that there is some historical discrepancy on Yik Wo. In the official record, Yik Wo is named as the defendant, or he was the individual charged with the crime in this instance. But according to some sources, the name of the man is Li Yik, and the name of his laundry is Yik Wo. According to these sources, when Sheriff Peter Hopkins arrested Li Yik, Hopkins confused the names, and the ensuing legal paperwork would forever identify Li Yik as Yik Wo. If that's the true story, then we can chalk that up as another experience of discrimination and bias against Li Yik. Either way, the Supreme Court case identifies him as Yik Wo, so I'll use that name when referring to the case. But I'll simply use Yik when referring to the individual. So here we go. An 1880 ordinance of the city of San Francisco required all laundries in wooden buildings to hold a permit issued by the city's Board of Supervisors. The board had total discretion over who would be issued a permit. Although workers of Chinese descent operated 89% of the city's laundry businesses, not a single Chinese owner was granted a permit. Yik operated a laundry business without a permit and, after refusing to pay a $10 fine, was imprisoned by the city sheriff, the aforementioned Peter Hopkins. Yik sued for a writ of habeas corpus, arguing the fine and discriminatory enforcement of the ordinance violated his rights under the Equal Protection Clause of the 14th Amendment. Noting that on its face the law is non-discriminatory, the Supreme Court of California and the Circuit Court of the United States for the District of California denied claims. The Supreme Court, however, unanimously held that despite the impartial wording of the law, its biased enforcement violated the 14th Amendment's Equal Protection Clause. The court's decision said that even if the law is impartial in wording, quote, if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution, end quote. So there's an example of selective prosecution. Hard to prove, but possible. The case of Yik Wo versus Hopkins illustrated a textbook case of what selective prosecution would look like. Most often, when individuals use the selective prosecution defense, they can't meet the necessary burden to show such systemic discrimination in prosecutorial decision making. So these cases are going to be few and far between.